Coming to you from a cozy little condo high atop Old Fourth Ward, Atlanta. Welcome to The Ron Show on America One Radio. Here's your host, Ron Roberts.
All right, thanks for listening, whether it's on the America One Radio app, AmericaOneRadio.com, on demand at ProgressiveVoices.com, or wherever you podcast. Should be an interesting show today. We have Georgia State Supreme Court candidate, former Representative John Barrow, who used to represent my district in Congress. He joins the show a little bit later. We'll discuss his running for office, and he actually broke some news yesterday, filing a lawsuit because he believes a judicial watchdog group is sort of binding his hands and keeping him from being able to run a campaign on issues that could be relevant at the Georgia State Supreme Court, namely reproductive rights. We'll talk about that in a little bit. Fani Willis making some headlines when she appeared at an event basically promoting her running for re-election as the Fulton County District Attorney. When she was asked this question, let me let you listen to this. Let me try and get the audio as good as I can for the reporter who asked the question.
You appear before a Georgia Senate committee without a subpoena?
Well, first of all, I don't even think they have the authority to subpoena me, but they need to learn the law.
So will you appear, yes or no?
I will not appear to anything that is unlawful, and I have not broken the law in any way. I said it, I'll say it amongst these leaders. I'm sorry folks get pissed off that everybody gets treated evenly.
All right. I think she answered that very well.
Okay, so here's the brunt of that situation. According to the Political Georgia blog this morning, Greg Bluestein, Tia Mitchell, Patricia Murphy, Adam Van Brimmer reporting in the Atlanta Journal-Constitution, Georgia Republicans may not get their moment in the spotlight grilling Fulton County District Attorney Fani Willis. That's because the prosecutor says, as you heard, she won't testify before a special Senate committee scrutinizing her. The GOP-led probe of Willis was orchestrated with the blessing of Lieutenant Governor Burt Jones, an ally of former President Donald Trump, who says she's abusing her office by bringing a far-ranging election interference case against Trump and several other co-defendants. Co-defendants, by the way, many of whom have already accepted guilty pleas and plea deals. Burt Jones, any word on that? Willis sees the Senate committee, back to the article, as an abuse of power. She said as much Monday at an event where she was joined by local religious and community leaders endorsing her re-election bid. We heard her response. The Senate committee held its most recent hearing last Friday, offering a prelude to legislation that lawmakers could pursue next year. GOP leaders slammed Willis for spending money on the racketeering case instead of shifting resources toward a backlog of criminal cases made worse by the pandemic at the Fulton County Jail. What's so interesting about all of this is that if the Georgia Attorney General, Republican Chris Carr, were doing his job, Fani Willis wouldn't have to be using resources at the county level to fight this case. A case, obviously, that has merit, or else you wouldn't have co-defendants taking plea deals. But I digress. Georgia State University professor Anthony Michael Kreis tweeting that Willis cannot reject complying with a subpoena out of hand. Rather, she will have to contest it in court. It's not clear to me, Anthony Michael Kreis writes, legislators can force her to testify because she's a constitutional officer, even if they can permissibly make some documentary demands of her office. In that case, we have an untested area of state constitutional law. Anthony Michael Kreis continues, my best guess is the touchstone of the analysis will be whether the committee's demands are broader than reasonably necessary to serve the General Assembly's legislative purpose. In Georgia, we don't have a unitary executive. Fani Willis will have to be accorded some executive privilege from the General Assembly, but she still has public duties related to the production of documents, but that falls short of showing up to testify. So where's that leave us? Anthony Michael Kreis finishes this tweet thread simple. Negotiation or litigation? Pop your popcorn, kids. To that end, Lieutenant Governor Burt Jones is essentially daring Fani Willis to ignore this subpoena, releasing a statement that said if subpoenaed by the committee, she will be required to appear or she will be in violation of Georgia law. This is what treating everybody evenly looks like, even if D.A. Willis doesn't like being held accountable. Which is rich because Lieutenant Governor Burt Jones, fake elector, has been the subject of judicial scrutiny himself and has done everything he can to avoid that. Most notably by fighting to have Fani Willis disqualified because she held a fundraiser for Burt Jones' opponent last election cycle. So petty. Let's get to the other big headline that dropped yesterday. This Georgetown University study revealed that Georgia dropped more than 300,000 kids from Medicaid and Peach Care for Kids. Ariel Hart at the Atlanta Journal-Constitution reporting this. The study authors fear the majority of them are now uninsured and might decide they cannot afford health insurance and health care as a result. Georgia and all states are reevaluating all Medicaid case files in a year-long national culling process after case rolls swelled during the pandemic. The process is scheduled to finish soon. Ariel Hart continues, Georgia's number of children kicked off Medicaid was bigger by December than the entire population of Augusta or Columbus. Georgia disenrolled far more children than California, a state that started with more than double the child Medicaid enrollment of Georgia, the report found. Pediatricians in Georgia have seen the experience in person as families show up to find out they're not covered and turn around and leave without care. Dr. Anu Sheth saying, it's so hard. Dr. Sheth is a pediatrician in Lawrenceville, board member of the Georgia chapter of the American Academy of Pediatrics, and continues, it's heartbreaking for the kids. The pro-life party, y'all. Ariel Hart's article continues, there's no way to track exactly where those children wound up. Despite Georgia officials' suggestion that many might have gone on to better insurance, the researchers say disheartening signs indicate that the vast majority may have simply lost insurance and perhaps gone without care. It's very likely that a substantial share of children losing Medicaid, especially those who disenrolled for missing paperwork reasons, likely ended up uninsured. That's Edwin Park, one of the study's authors addressing the Georgia data. Missing paperwork is the most common reason behind Georgia's disenrollments, Ariel Hart reports. Medicaid is the government health insurance program for poor children and some poor adults, such as some who are elderly or disabled. Some may meet eligibility requirements by working at least 80 hours a month or attending school. Scrolling a little bit further down the article, listen to this. The top 3 states for disenrolling children, Texas, Florida, and Georgia. Anyone surprised by this? When taken together, are responsible for 45% of the nation's disenrolled children as of December. Ariel Hart continues, Georgia officials responsible for Medicaid, the State Department of Community Health and the State Department of Human Services, point to huge numbers of signups for private plans on the Affordable Care Act marketplace. That could mean they suggest that those kids' families' incomes rose and the kids moved and got better insurance. However, the Georgetown researchers said very few of those new signups were children. A small fraction of the number disenrolled by Georgia. Dependents are expensive on ACA and other private plans, they said. When it comes to keeping children who should qualify for Medicaid covered by Medicaid, the Georgia DCH and DHS officials say they've gone to extra lengths for the unprecedented task. They've more than doubled their expected hiring of caseworkers to more than 1,000 for 300,000 disenrolled. Indeed, Sheth, the doctor said, she's worked with state officials on the issue and was impressed by their desire to try and make it work. She sees they have implemented heavy advertising to alert patients they need to check in with Medicaid office. She's seen them change some policies to make continued enrollment easier. One thing that remains a problem, she said, the state's gateway computer system for Medicaid. The Atlanta Journal-Constitution's reporting also found Gateway to be an obstacle for some individual patients, especially those with only cell phones for a computer. Glitches in the Gateway mobile computer interface gave misleading information on patients' accounts, for example. AJC reporting also found that enrollees were told to seek help at the Medicaid office only to find it closed or that caseworkers work remotely. Enrollees have recounted rarely being able to get through to caseworkers by phone. The study authors say, according to Ariel Hart's reporting, there are measures that states can still take, but Texas, Georgia, and Florida, the report said, are among states that, quote, have prioritized the hasty disenrollment of adults and children despite projections that many still remain eligible. Some examples they cite, Ohio has applied for official federal permission, called a Medicaid waiver, to allow children from babies to 6 years of age to stay on without going through the annual application. Ohio, a Republican-led state. In addition, other states' computer systems, on average, are finding much more enrollment qualification information automatically in accessible databases than Georgia's is. So far, Arizona has been able to re-enroll 75% of its Medicaid beneficiaries with automated database searches. For example, said Joan Alker, executive director of Georgetown's Center for Children and Families, which released the study. In contrast, Georgia has re-enrolled 35% of enrollees with automatic searches. She says many of them should be covered by Medicaid, and that's their affordable choice for coverage. So they're likely facing a gap in coverage, which is not good news. Georgia officials told the Atlanta Journal-Constitution they have expanded the ways that the computer system can make a Georgia enrollee automatically requalified for Medicaid, and Georgia patients will see that. The state continues using implemented improvements to minimize the number of procedural terminations and maximize the number of ex parte renewals, according to DCH. Okay, as I mentioned, Georgia State Supreme Court candidate, former Congressman John Barrow, will be joining the show 2 weeks until the primary election, but also he's running against Justice Andrew Pinson. It's a nonpartisan race, however, it appears on both primary ballots. He filed a lawsuit yesterday. The press release that he sent citing former Congressman John Barrow has filed suit today challenging proceedings aimed at stopping him from stating his views on abortion rights. Barrow is running for the Georgia Supreme Court against Justice Andrew Pinson, who was appointed to the court last year after defending Georgia's controversial abortion ban laws as Solicitor General. Acting on the complaint of an anonymous party, the Georgia Judicial Qualification Commission initiated a secret proceeding against Barrow last Wednesday, threatening to sanction Barrow for public statements in which he had announced his views in support of the rights of women under the Georgia Constitution. In order to defend his First Amendment rights as a candidate, Barrow filed suit against the JQC in federal court. The JQC is the body that polices the state judiciary and has the power to recommend to the Georgia Supreme Court that any judge, including Supreme Court justices, can be sanctioned, up to and including removal from office. The JQC claims to have the same authority over candidates for judicial office as it has over incumbent judges. Kind of fascinating that his hands are bound, and this is one of those few states we talked about the reverse coattail methods that has really nothing on the ballot that would encourage those who wish to defend a woman's right for reproductive choice to make that case at the ballot box, except in this case. John Barrow joins us next to discuss here on The Ron Show when we return on the America One Radio app, AmericaOneRadio.com, on demand at ProgressiveVoices.com, or wherever you podcast. Welcome back to The Ron Show. Follow us on social media, preferred platforms, whatever. Twitter, X, Instagram, Facebook, we're all over. Threads as well, at Ron Show ATL. Joining me, former Congressman John Barrow, used to represent my district back in the day. And I remember when you won the race, I was like, uh-oh, this is a Democrat in a GOP-leaning district, and he's not going to be able to last long if the hyper-partisanship that we knew then was going to continue, and it's gotten only worse since then. John, thanks for joining me. I appreciate the conversation.
Glad to be here, Ron. Thanks for having me.
So, I mean, you're a Georgia boy. You are true and true. I mean, you were born in Athens, Georgia. You went to the University of Georgia. You were raised by military parents. You have all the makings of what we would see as a true to his Southern roots Georgian. Obviously, in the political arena, though, it depends which side of the aisle you're going to wander into. I get you're running for a nonpartisan seat, but you were a Democrat in Congress. So does that ever come up? I mean, I'm sure a lot of people wonder that. I get that all the time. Wait, you were raised in Georgia, you grew up in the suburbs, you're a white male, and yet you're liberal. Does that ever perplex people that don't know you through and through?
You remind me of that scene in Sergeant York when the traveling salesman is up in the backwoods of Tennessee and says, "How'd you folks get into this place?" He said, "We was born here.
Yeah.
We was born here."
Exactly.
That's how I got here. I was just born here. I am a seventh generation Georgian. My family's owned the same farmland for over 2 centuries. My mom and dad were both decorated veterans in World War II. My dad was the closest thing to Atticus Finch in a 100-mile radius of Athens where I grew up. And he'd take me to court sometimes with him when he didn't have a busy calendar or something, and I'd go with him like little Jim Finch going with his dad to go see the clients. And I tell you, I learned an awful lot about the law, and its impact on people long before I ever went to law school. My dad was of the civil rights troubles, and he advised those under his authority to act in compliance with the constitutional rights of the freedom riders and others, and not in compliance with the unconstitutional segregation laws at the time. My parents were very courageous leaders in the fight to desegregate the University of Georgia. And as it happened, my dad was the judge who actually presided over the case that desegregated our public schools in Athens. And I was in the first class to go all the way through the fully integrated consolidated high school. So I tell you, I was born in To Kill a Mockingbird, but I graduated from Remember the Titans. You ever seen that movie? I mean, that was the span of years of my youth. I went to University of Georgia after graduating from there. I became one of the youngest members of my law school class at Harvard Law School, a class that had John Roberts in it, but also had Russ Feingold in it, and me. I think 2 out of 3 ain't bad.
We'll take that.
So, and after that, I clerked for the Fifth Circuit and came back home because I wanted to practice law in the real world with real people having real problems. And boy, I got a lot of that. 25 years of practicing law, hanging a shingle out on the main square, wondering where our next case is coming from, and making my living through my reputation, actually representing people, trying cases before juries all over the state. I'm running for the Supreme Court against a guy who ain't had any of that kind of experience. My opponent is a guy named Andrew Pinson, the youngest and newest political appointee on a Supreme Court that's got lots of political appointees on it. He was a former Clarence Thomas law clerk. He is an officer in the Federalist Society, and he was the judge, the lawyer rather, the chief appellate lawyer for the state of Georgia in the case where Georgia joined Alabama and Mississippi in the case that overturned Roe versus Wade. That's his record. I'm running for the Supreme Court because I believe that women have the same rights today under the Georgia Constitution that we used to have under Roe versus Wade before it was overturned with the help of my opponent. My opponent does not believe that, and that's the central issue in our election.
And here we are, like literally, I before we even came on, I was telling John, like, we'll do a little bio, we'll dive into the meat and potatoes of the race. And John, you did an eloquent job there, man. You went right into the, like, I'm concerned that we're even allowed to have this conversation because, well, I'll let you explain. It seems that there's, judicial review that, like, doesn't want you to talk about this.
Well, my opponent is taking his cues from the same playbook that we had in Wisconsin last year, where the voters had a real education as to what the law is and the rules are about campaigns for judicial office. The losing candidate up there was a guy who said, I'm going to be fair and impartial. That's all you need to know about me, and that's all I'm allowed to say. Whereas his opponent, the judge who was elected, I hesitate to say her name because I'll probably mispronounce it.
It's a lot. Yes, it's a lot.
He campaigned openly on her belief that women had rights and her belief that the legislative and congressional lines in Wisconsin had been rigged by the legislature. And she campaigned openly on a statement of her beliefs because she believed that the voters had a right to know what they're voting for. And it turns out that she was right and her opponent was wrong, and the voters not only knew what they were voting for when they were voting for her, they elected her, and because they wanted to elect a candidate who actually gave the voters some idea of what they stood for. Now, the guy on the other side said that's wrong. That's wrong. We shouldn't do that. Judges don't have opinions. They don't have opinions until they read the briefs and issued a written opinion. What baloney. He also said that if you do have opinions, you got to keep it to yourself so that the folks will think that everything's on the up and up. What baloney. That's exactly how we got a Supreme Court full of people who stated under oath, all but committing perjury, but implying up one side and down the other. That they're going to follow precedent. Roe versus Wade wasn't just precedent. It was a precedent on a precedent. It wasn't a precedent on a precedent. It was a super precedent. And the very first chance they get, they dog cuss the decision and kick it into the gutter and say it's not even worthy of being called a precedent. Well, we got a Supreme Court full of people like that because folks would not state what they really believed, pretended they didn't have an opinion when obviously they had all kinds of preconceived notions as to what the law ought to be. And now we got a guy down here in Georgia who's doing the same thing. He's running on a platform that I'll be fair and impartial, but I'm not able to say anything about something that's controversial that might come before the court because that's a violation of the rules. Well, it turns out that's just not true. The rules used to say something like that 25 years ago.
All right, stand by. We're going to pivot, and we're going to let John explain exactly what happened 22 years ago in the U.S. Supreme Court and why the hypocrisy is rife. When the Ron Show returns on the American One Radio app, AmericanOneRadio.com, wherever you podcast.
Broadcasting 5 days a week to make common sense common again. This is The Ron Show on America One Radio.
We are with Georgia State Supreme Court candidate, former Congressman John Barrow. John, sorry, we had to take a quick, hard break there real quick, but you were explaining how you filing this lawsuit to discuss an issue that is going to be central to a lot of voters' decisions, not just in the primary coming up. And by the way, your election comes up on the primary ballot, the primary calendar instead of the general election calendar, which I think is kind of unfair, but that's another conversation, I guess, for a little later. But you were explaining how the rationale that they're trying to take to keep you from even speaking about your position on abortion and your opponent's position on abortion actually was ruled on by the Supreme Court and by Justice Clarence Thomas, who had a role in this, who your opponent clerked for.
Well, get this picture. It's back in 2002, okay? And liberal Supreme Court justices, liberal state Supreme Court justices all over the country are being savaged because some of them were getting to discover in their state constitutions a right to same-sex marriage that wasn't spelled out in the Constitution, but was implied by such things as the equal protection clauses and due process and whatnot. And they were being savaged by conservative candidates who were running against them and turning them out of office, relying on the public mood of the time,
right?
Which is certainly not what it is today.
And obviously, which was used to help get President Bush reelected in 2004 as well.
Absolutely. And one of these conservative candidates was running up against the culture of silence, the culture of closed mindedness that you see in judicial campaigns for most of the last half of the last century. There's been a culture promoted by the ABA and by judges associations and by judicial offices and administrative offices and by the bar associations, all trying to make judicial elections as meaningless as possible by passing rules explicitly prohibiting judges from talking about the issues that might come before them, by taking the position that any such discussions of a judge's views on what the law is in essence a promise to rule in a certain way or a promise to be partial to one side or another. And these rules have been in effect for decades in the last part of the last century. So there used to be rules to this effect, and folks used to play by them. But in Wisconsin, there was a conservative candidate for Supreme Court. He says, I want to be able to say what my position is on gay marriage, and these rules won't let me. So he went to court, and he challenged the rules, basically saying, I have a First Amendment right to speak my mind on issues, even issues that are controversial, and even on controversial issues that may come before the court. Well, the state, the bar authorities and the judicial watchdogs, they all hemmed and hawed and went up to the Supreme Court. And Scalia and Thomas and company made short shrift of all these rules by pointing out, he said, in essence, look, you don't have to elect your judges. But if you do elect your judges, you cannot conduct those elections under conditions of state-imposed voter ignorance. Mm-hmm. If the voters are going to be tasked to choose their judges, they have a right to ask the judges what their opinions are on matters that are important to the voters. Mm-hmm. And if they have the right to ask, the judge has the right to answer. And so they basically found that judicial and decided as a matter of constitutional law that judicial candidates have the right to speak their mind on controversial matters, even controversial matters that like to come before them, because the voters have the even more important constitutional right to know what the hell they're voting for.
Mm-hmm.
So that's been the law for 20 years now. And judicial codes all over the country have been amended to embrace that. Georgia's code has been changed to reflect that. It used to say you could not say anything except you couldn't talk about things except maybe your work ethic or your academic background or, little meaningless things like that. But you could not talk about any issue that might come before the court. Not anymore. The Georgia code says, like all of them that have been brought up to date, say that this code does not prohibit a judicial candidate from publicly stating his views on disputed issues. And it cites this Supreme Court decision, which says you not only have a right to talk about it, you have a right to talk about disputed issues, even if it's likely to come in front of you, because the voters have the right to know. Now, what it really means, what it boils down to, is that the judicial candidate has the right, if he wants to remain silent.
Mm-hmm.
Because what he says can and will be taken down and used against him. And so does his opponent. But the rule also is a candidate for judicial office has the right to speak. The constitutional right to speak his mind on these issues. He doesn't have to remain silent. And because that's the only way in which the voters can hear what they need to hear in order to be able to make up their mind. Now, fast forward to today. For the last 2 months, I've been campaigning publicly, openly, and plainly across the state of Georgia, stating my view that I believe, my opinion now, it's my opinion, that women have the same rights under our state constitution today that they used to have under Roe versus Wade. And just this last weekend, just 2 weeks before the election, a secret Star Chamber proceeding has been initiated by the judicial watchdog agency in this state by an anonymous complainant who has brought the complaint that my statement of my opinion as to what I think women's rights are under the state constitution is not just an opinion, it is a false statement of settled Georgia law.
Well, that's ironic.
And it is so false that I can be sanctioned for having said it. And they're trying to stop me from saying it.
So let me get this right. The overturning of Roe v. Wade, which upset established law, now making the Georgia legislative and the governor's decision and its 2019 law effective. Now it's established law, and we can't talk about that.
Absolutely, that's right. Now, of course, I think it's all baloney. What they're doing is they're falsely equating a statement of what your views of the law is with being partial toward one side or another in a lawsuit.
Right.
Again, Scalia and Thomas made short shrift of that. They said, no, impartiality has to do with being biased for and against a party to the lawsuit.
Yeah.
But judges are not expected to be impartial when it comes to the law. They're expected to have pretty substantial preconceived notions as to what the law is or what the law ought to be. That's why if a judge doesn't have any established preconceived notions as to what the law is, he's got no business being a judge.
We are with former Congressman John Barrow running for the Georgia State Supreme Court seat. And here's what I find interesting about your predicament. The thought process that I think that a lot of folks on the right are trying to apply here would be like, if our state Supreme Court were simply seated by people who were appointed, then you wouldn't want to hear from them on their political views. But because in theory anyway, the Supreme Court is supposed to be seated by voters, they're trying to apply, I think, what we're holding to the federal Supreme Court to the state Supreme Court. And I realize that there are appointees on the bench for various reasons. But yeah, if voters are going to weigh in on something, we should know who we're voting for and what they believe in. And yet,
I think it's pretty simple. It's pretty simple. The voters have a right to know what they're getting.
Right.
They have a right to know what they're getting. And to have someone say, I'll be fair and impartial. And the other guy said, no, I'll be fair and impartial. And the guy said, no, I'll be fair and impartial. The voters aren't getting any meaningful information whatsoever. That's what Scalia said. And while I don't agree with a lot of things Scalia said, he's dead on the money as far as this is concerned.
Well,
these elections, where you impose silence on the candidates on issues that the voters really care about, are shams.
Yeah, and I mean, at the end of the day, what are you supposed to do? Run like a high school race or something like that? Vote for me, I'm or just based on popularity, or I don't. I
It's
don't
very
just.
simple. You run on the fact that you've been appointed, and
Yes.
therefore you have a certain head start on the other guy, and therefore you got experience on the job, and therefore it's no contest. So you got to elect. You got to elect the guy who's been appointed. I mean, the fix is in for that. Look, there's nothing wrong with appointed judges, so long as folks know what they're getting.
Right.
But elections are how the people decide whether or not the judicial philosophy that is governing their fate is something that they believe is a part of this century or 2 centuries ago. The voters have a right to know that, and they have a right to vote on that. And they don't get it from the kind of gagging of the candidates that the Judicial Qualifications Commission in Georgia has initiated in our case. What we've done, of course, is we run straight over to the federal court and haul them in there to make it plain to them that if they're going to try and shut me up and keep me from expressing my opinion as to what the law is, by falsely accusing that I'm making a false statement of settled law in the matter, if they're going to try and shut me up, I'll have to explain it to a federal judge.
And this is listen. I am not a law school student. I've never even been near a law school. This seems like such an open and shut case for you that you have Supreme Court precedents with Scalia and Justice Thomas weighing in on this. And yet, as I'm reading from the Atlanta Journal-Constitution, other judicial leaders have raised sharp concerns about your approach. 5 former Georgia State Supreme Court justices and 10 past presidents of the State Bar of Georgia encourage voters to, quote, demand that our judges be nonpartisan and refrain from making public commitments about how they will decide cases and issues. That drips of politics right there.
Well, it's interesting that all but one of the former Supreme Court justices who signed that letter are either co-chairs of my opponent's campaign committee or members of his steering committee. And you would think that a former justice of the Supreme Court who is invoking his former high office in order to impress upon the readers the seriousness and importance of their views would at least point out to folks that they're getting a lecture from folks who are betting on the other team. But you're not getting that from these folks. Maybe they subscribe to the Clarence Thomas School of Full Disclosure. I'm not sure. But the point is, the rules are not just what the judges want them to be. They include what the Constitution requires. And the Constitution requires that if candidates want to, they have the right to speak their mind on controversial matters likely to come before them because the voters have a right to know what they're voting for. And if my opponent wants to take the fifth, which is what he's doing, he has the right to take the fifth. But this ain't a criminal trial. We have the right to construe his silence against him because the reason he's taking the fifth is because his record is so clear that he clearly opposes women's rights. He's fought to defend the Georgia abortion ban in federal court. He was the chief appellate lawyer for the state when Georgia joined Alabama and Mississippi to overturn Roe v. Wade. He's already voted to uphold the abortion ban in just about every way that a lawyer could. How can we expect him to be any different now that he's been appointed to the only court that can do anything about it? And our state courts are the new battlegrounds on lots of fronts. Gerrymandering for one, but women's rights on the other. They are the new courts of last resort. And so it makes it that much more important that people who want to offer themselves for that office have the right, if they choose to do so, to tell folks what they think about these issues, because the voters are going to be stuck with the result.
We're with John Barrow, former congressman running for the Georgia State Supreme Court seat that is currently held by appointee Andrew Pinson, who has a record, as you've heard John allude to, on reproductive rights. We were talking a little bit yesterday on this show about the reverse coattail effect, how there is a strong likelihood in many states, some of them swing states, that there are races down the ballot that may affect the presidential race. Obviously, yours is one that I think would draw people to vote in a primary election where primary turnout's probably going to be super low anyway. But are you seeing some enthusiasm for folks showing up just because your race shows up in May instead of November?
Oh, let me tell you, at the grassroots level, where networking is going on with serious and important influences across the state, this election has taken off. I mean, we have got people who are volunteering and stepping forward in all kinds of ways. It's not something that you see because it's scattered all over the state. But the people who helped elect John Ossoff, the people who elect Raphael Warnock, the Pave It Blue people, the Indivisible people, they are really fired up about this because they see the importance of electing someone who stands up for their views on this important matter of constitutional law on the one hand, but they also are outraged at the attempt to shut down this campaign. You know, the commission that I've talked about is basically demanding that I pull down my ad and pull up all the yard signs all across the state because they say vote for choice. I mean, that's what we're up against. Folks who are trying to shut down an election, a campaign in the closing weeks of an election, so as to influence the outcome of the election in favor of their preferred candidate. And we're not going to be bullied and we're not going to be stopped. And the voters across the state, the activists across the state are really stepping up. But we need help. I want everybody within the sound of our voice to go to barrowforgeorgia.com and send me all the support that you can because we need it. We have an unbelievably tight time frame here, just 2 weeks before the election. And still there are a lot of people who don't know that there's a judicial election on the ballot. And still there are a lot of people who don't know that one of the candidates on that ballot stands for women's rights and the other doesn't. And all we need to do in this election is get that across to folks. We don't have a turnout problem. We don't have a persuasion problem. The only problem we got is making sure the folks know which side these two candidates are on. It's the lowest burden you got in electoral politics. And with today's information economy, we can do that with amazing efficiency in very short time. It just costs money. And that's what we're short on. So I hope that all the listeners who care about the outcome of this election in this state, but also all these elections across the country, will go to barrowforgeorgia.com and send me some support, because that's the only way we're going to stop this nonsense, is winning one of these elections and getting the other side on the run.
So my last question to you is, this lawsuit you filed yesterday, how quickly is the judicial system going to act on this? How soon will they? You're not exactly gagged right now. Your hands aren't tied. You are talking. But how soon can decisions be made that, or is this just something that's going to play out beyond the primary election date?
Well, it's been moved from a secret proceeding from a judicial watchdog agency to where it would have gone next, which is to a public proceeding in which they actually accusing me of breaking the rules, which of course would be used by the other side pretty much, right out of the Trump playbook or the Kemp playbook to try and smear me with the fact that I'm being investigated or with possible sanctions.
Right.
We're taking it to the federal court. Where they don't have that initiative. It's going to be up to the judge to decide what happens. We only got 2 weeks left to go. The point is, they cannot gag me in secret. They can't drag me into one of these public proceedings where the accuser and the judge are the same parties. We're going to have an opportunity to air our position on what my rights are in federal court. These are federal rights that belong to all of us, and they're vitally important, because if they can shut down an election here in Georgia in this way, they can do it anywhere. So it's vitally important, not that we just show up and make the right legal arguments, but that we show up at the polls to deliver the result that will discourage people from trying to pull this kind of stunt again.
Well, what's interesting is that the sanctioning could lead to your being removed from the office you could be elected to. That's the catch-22.
More than that, this group claims the authority to be able to disbar somebody. I mean, this is they're not urging me to do something like the article the paper said. They're demanding that I immediately make changes even before I've had an opportunity to be heard. They're demanding that I bring my statements into conformity with the law without saying what I can say under the law. I mean, this is open and shut. This is old law, settled law, but it's folks basically trying to rehash or regurgitate this public conception that somehow judicial elections have to be this way because that's the way they've always been. That's another thing the Supreme Court pointed out is ridiculous. Judicial office haven't been like this forever. It's only a recent innovation, and they shut it down colder than a mackerel because it deprives the voters of any meaningful opportunity of knowing what they're voting for. And again, you don't have to have elections for judges if you don't want to, but if you do, you can't have them under conditions of state-imposed voter ignorance. And this proceeding to try and shut me down and keep me from expressing my opinion as to what I think the constitutional law of this state is just that, an attempt by a state agency to impose a state of voter ignorance on the voters.
John Barrow running for the Georgia State Supreme Court seat currently held by Andrew Pinson. Best of luck on the campaign trail and in the courtroom, and we'll see you at the ballot box in 2 weeks. Appreciate your time joining us on the Ron Show today.
Thank you, Ron. I appreciate it.
All right, we're in the home stretch. Thank you for listening on the American One Radio app, AmericanOneRadio.com, on demand at ProgressiveVoices.com, or maybe you're just listening via podcast in your leisure. Hey, thanks. Appreciate that. So as we're formulating the show today, NBC News dropping the bombshell that Stormy Daniels is going to testify today in the Trump hush money / election interference case. And Donald Trump on Truth Social. Now remember, this gag order, he's been tiptoeing. I mean, to the point now where like the 10th time he's been fined $1,000, which means nothing to him. That's walking around money for Donald Trump, right? The 10th time he's been admonished for violating a gag order, the judge in that case has said, next time I'm going to have to consider jail, which isn't saying he's going to send Trump to jail, but I think Donald Trump's actually concerned about going to jail. I say this because Stormy Daniels coming to court to testify sent him into a tizzy on Truth Social in a post that he then removed, but we have the post. I have just recently been told who the witness is today. This is unprecedented. No time for lawyers to prepare. No judge has ever run a trial in such a biased and partisan way. He is crooked and highly conflicted, even taking away my First Amendment rights. Now he's threatening me with jail, and they have no case. This according to virtually all legal scholars and experts. Sure, Donald. Why isn't the fake news media reporting his conflict? That was a post that he posted this morning around 7:30 and then later took down. I'm guessing not because he thought better of it, but because his lawyers probably thought, do you really want to go to jail? Now, I'm not necessarily sure that this post violates the gag order. I think it really walks right up to the line. But again, I'm no legal scholar. You heard me talking to a state Supreme Court candidate. Do I sound like somebody who's been to law school? Of course not. I'm an idiot. But I'm an idiot who kind of knows a few things. Anyway, no, I don't think that Trump's post actually violated the gag order, but boy, it walked right up on the velvet rope there. But he took it down anyway, which tells me that he actually doesn't want to see the inside of a jail cell. And maybe that's a good thing. Or maybe this is the new way now he gets the word out. Post, let people screen grab, take it down so that he's not seen in violation, and then let the judge in the case decide if a deleted post violates a gag order. Man, we live in some weird times. Do we not? Live in some weird times, man. Former president indicted in court now because he used an attorney to pay hush money to a porn star because of an affair that he had, fearing that the affair, if it were to come to fruition, would somehow derail his presidential campaign back in 2016, who is also, by the way, considering for the vice presidency a governor who wrote a book, an autobiography, where she recounts killing the family dog and then turned to look at the goat, too. What did the goat do? And now wants to backtrack because, and by the way, said in the book that she spoke to Kim Jong-un and has had to go back and say, well, no, actually, I just went to so it was the DMZ. It wasn't technically North Korea. And now we have a Georgia State Supreme Court candidate who is using Supreme Court precedents and citing Antonin Scalia and Justice Thomas, and he's a Democrat running on reproductive choice. This is the stuff that sort of makes the Matrix trilogy movies feel somewhat legit, because I feel like there's something wonky in the Matrix. If you'd have told this child of the 80s that Donald Trump was going to be president and then would wreak all this havoc on our governance at every level, into the judiciary at the state level, I'd have said, no way. No way. Then again, there were people in the 1950s who thought, Ronald Reagan for president, the actor? No way. It's going to do it. Show notes at RonShowATL.com. Tomorrow, 9 to 10 a.m. on America One Radio. We'll see you there.